Certainly, if you have any questions today, feel free to enter those into the Q&A function at the bottom of your screen, and you can also communicate with us through the chat. And we'll be sure to get those to our judges today. And helping us moderate this discussion, we have Vincent Skebby. He is the chair of the Young Lawyers section. He's here today to guide this discussion and help us meet our new judges. So Vince, thank you for doing this. It's a pleasure to have you.
Thanks, Dominica, and good afternoon, everyone out there. I'm really excited and honored to help moderate this panel and, help kind of guide this conversation. I think the goal of today is try and keep things conversational. This is a really good opportunity to introduce our judges before us as lawyers have to stand in front of them with, something at stake, whether it's, a client or some other matter. So, the goal is let's try and keep this pretty light, relaxed, but of course we're here to answer any of the questions you may have. So feel free to answer or ask them at any time. To get things started, I really want to start by going around the room, let all the judges introduce themselves. We'll go one at a time. Just give me a quick introduction, where you graduated, what your experience was prior to running for judge, and, for the theme of trying to keep things a little bit light, give me some kind of fun fact about you that has nothing to do with the practice of law. Whether it's like a favorite ice cream or favorite movie, favorite book, something non-law related would be preferred. So we'll start with Judge Celebrezze. We'll start with you.
Well, good afternoon, everybody. I'm Judge Celebrezze, Nick Celebrezze, since a lot of you, I'm sure, know my cousin Frank or my sister Leslie. I'm in the juvenile court. I'm known as Ann McDonough's junior judge. She's my senior judge. Prior to joining the bench, I graduated my undergrad from the University of Akron and from law school, went to Cleveland Marshall. I was an assistant county prosecutor for a couple of years back in 2004 to 2006 before becoming a four-term city councilman for the city of Parma, and then later the state representative for the 15th House District, which I did for 7 years. 5 of which I was the assistant minority leader. I then left politics briefly, moved to Vermilion with now my ex-wife. I got divorced, moved back into the county, and then ran for judge in this past election cycle at juvenile court. I'm an avid soccer player, but now even everyone tells me I'm too old, so it's just diminished returns at this point. As you could tell by my physique, every food is my favorite food. So there's no big surprises there.
Perfect. Let's go to Judge Ryan.
Good afternoon, everyone. I want to thank the CMBA for organizing this great event. And I was hesitant to participate because I thought it was another judicial forum, or one of several that we attended while on the campaign trail. And while I really like Judge Celebrezze, Judge Saffold, Judge McDonough, Judge O'Donnell, spending 12 months of the year with them earlier is a lot, especially since they're not your spouse. So I was like, well, should I go to another forum? But in all seriousness, I am thankful to have been invited. I actually graduated from Allegheny College in '93, and then I graduated from Cleveland State University Law School in 1996, began my career as assistant prosecuting attorney for the city of Cleveland. Then I ventured over to work for Mayor White in their Office of Professional Standards, which dealt with complaints filed against police officers. And then went back to the prosecutor's office for a while, and then went to go work for Fields and Associates as an associate attorney there, doing criminal defense work, as well as a lot of personal injury work and a lot of civil litigation. And then I was fortunate to be hired as a magistrate for the city of Cleveland, did that for 4 years before getting elected as a Cleveland Supreme Court judge in 2005. And I was there for 7 years before I was elected to the juvenile court, and I was there for 10 years before I had the fortunate opportunity to be elected here at the 8th District Court of Appeals. I've been here for about 4 weeks now, and I've enjoyed the time that I've been here. I guess we'll get into more discussion about the difference between this and the work I've done in the past. One interesting fact about me is that I wrote a book, and it's my favorite book, of course. despite all the other books that I've read. And the title of the book is The Least Likely: From the Housing Projects to the Courthouse.
Wonderful. Everybody loves something that they've created most of all. So
Right.
wonderful. Thanks, Judge Ryan. Let's go to Judge Saffold.
Good afternoon. Thank you for having me. If it looks like I'm driving, it's just a new Zoom app, so don't be distracted by that. I've been on the bench all of about a month, and it's been a joy. It's really a fantastic opportunity to try to reach people and help people, which is exactly the reason why I ran. So it's really been a very satisfying 4 weeks. Having said that, I've spent 27 years trying to help people as a criminal defense attorney, and 2 years in the prosecutor's office. So 25 as a criminal defense attorney, and then 2 as a prosecutor for 27 years total. So I came to the bench with a great deal of experience, but no real feel for what it would be like to actually be a judge. And it's just, I can't emphasize enough how awesome it's been thus far. In terms of something unrelated to the law, I spent about the last 15 years coaching football. So I've worked with kids on the east side of Cleveland, numbering in the thousands, trying to kind of reach them and impact on their lives or in their lives outside of football, but sort of using football as a vehicle. I ran a youth program called Family Involvement Reaps Excellence, or otherwise known as the FIRE. But so I'm anxious to take questions, and I was intrigued by one of the questions I saw in the planning of the event, which was, how do we measure our success? And I just think that's a really interesting question, because there are all of these matrices that people use. And I think at the end of the day, it really comes down to whether or not you leave the bench feeling like you've impacted positively on people. And that's probably the joy I'm talking about when I talk about being a judge.
Great. Thank you, Judge Saffold. And the injury lawyer in me just wants to remind you, don't text and drive.
It's a Zoom app, man.
Don't Zoom and drive. Had to. Sorry, guys. Let's shift over to Judge McDonough.
Good afternoon, everyone. I trying to think of all the things that we're supposed to go over, but yeah, I graduated from The Ohio State University and then went to Cleveland Marshall at night. And then I worked for the prosecutor's office out of law school and during law school. And then I went on to be a staff attorney for Judge John Russo when he was the administrative judge. And then I've been at juvenile court since 2016 as a magistrate, and then as assistant legal counsel for the court. I'm trying to think, I want to thank the CMBA for offering this today. And different than Judge Ryan, I am sitting in Judge Ryan's old chambers right now. I don't know if it looks familiar. And different than Judge Ryan, he said he didn't want to come see us. I was looking forward to seeing all my friends from the past year. But in something non-related to court about me is what's coming to mind is really when I'm not here, I am probably watching a child play a sport somewhere. So I'm a mom to 2 young boys and watching a lot of swimming and flag football and basketball right now.
Wonderful. Thank you. We have Judge Kelley and Judge O'Donnell join us. So we'll go to Judge Kelley. Why don't we start with you? Give us a little bit of background. Tell us, a little bit about your education, what you did before you got on the bench, and then, something fun fact about you that is non-law related. Judge Kelley?
The judge, he mentioned his connection is a little bit choppy.
Yeah.
Division doesn't have as great as technology as juvenile court does.
Yeah, we can hear you loud and clear. Can you hear me? Am I yes. Coming in and out?
Yep. I spoke too soon.
Okay, so I'm going to talk, and if it doesn't work, if you could just mute me and then come back to me, and I'll figure out if I can find a better connection somewhere else or try to find a hard connection. So, Kevin Kelley, I'm not sure exactly what the question was that was posed, but I believe it had something to do with our background and what we did, and so I'll just kind of wing it. So, my name is Kevin Kelley. I am honored to have been elected to the Court of Common Pleas. Prior to my election to the court, I've been an attorney for 18 years, practicing mainly civil litigation. Before that, I was a social worker for almost 15 years. Part of that overlaps the time that I went to law school. And I've been a member of Cleveland City Council and the president of Cleveland City Council for the past 8 years. So I'm really, it kind of doesn't matter what experience you had prior to being a judge, because it's not the same when you're not a lawyer, when you're not the advocate, when you have to, look at everything through a different lens, and finding the transition to be just tremendously enriching. But it's a big, steep learning curve that I'm on, and I assume the rest of us are, because regardless of any preconceived notions I may have had about being a judge, when you're sitting on the bench, it's a different perspective that you have to take, and you can't be the advocate. But that being said, I'm honored to be serving the people of Cuyahoga County. I did hear, even though it came in and out, I heard a little bit of what Judge Saffold said, and I think if we have to all take a step back when you're measuring success at this job. The Cleveland.com plain dealer can write a story that may lead you to certain conclusions, but there are nuances with each case. There's got to be, maybe there's some way of measuring performance, but just for example, one of the judges that has the lowest number of people in the jail has a high jail day count because of the charges that a small number of the defendants have. Another judge is a frequent user of probation, and when people have violations, they come back to that judge. So there is no perfect measurement. I don't want to sound overly idealistic or in any way, but right now my goal is to achieve a just result for every case and work hard. And I believe that if I do that, the numbers will naturally kind of come in line. But I don't have a preconceived notion of what a docket number should be, or what number of defendants in the jail should or shouldn't be, or jail days. I think that every case is different. And my approach really is just that, is, working with the attorneys, letting the attorneys kind of guide how the case will resolve, but how do we get a just result? And in doing so, then in a year, I'll look at the numbers, and I believe they'll be better because of that. But then I'll reassess what is success, because right now I don't have a notion of success.
Sure. And one last thing, if you can hear it, Judge Kelley, why don't you give us a fun fact, something about you that has nothing to do with the practice of law? Tell us something about yourself.
I'm the father of 5 beautiful daughters, and I play the harp.
Oh. How long have you been playing the harp? That's really cool.
Yeah, a long time, but then I put it down for about 15 years when I had kids, and I just picked it back up again recently.
That's great. All right, last judge on our panel, Judge O'Donnell.
Hi, good afternoon. Can you hear me?
Yes, loud and clear.
Oh, good. I was having some, on top of my voice just now coming back after being sick, I was having some technology issues. So I'm glad that I'm coming through. Thank you so much for putting together this panel and for having me. I am Jennifer O'Donnell, and I am one of our new judges in the Court of Common Pleas General Division. I went to law school at Case Western. I graduated in 2007, and then I immediately started my former career with the Cuyahoga County Public Defender's Office. I was a public defender for 14 years, and I, in that way, I'm a very unique addition to the bench. We have a 34-judge bench in our general division, and I'm proud to say that I'm the only former Cuyahoga County Public Defender on the bench. And, certainly coming from that background, I do view things in in a bit of a different way. And I have a, you know, a unique experience that I bring with me, and I'm hopeful that it will serve me well on the bench. As far as something non-related about me, I was kind of, you know, I was interested to tell you all that my favorite ice cream flavor is cookies and cream. I saw that, you know, jump out from the notes. And to be more specific, Mitchell's ice cream, cookies and cream, because it's the best. In addition to that, you know, when I'm not, you know, being a judge, I am a mom to a 5-year-old son who's in kindergarten. And in what very little free time I have, I am an avid Pelotoner. So that's really what I like to do in my free time.
Wonderful.
Thanks.
Thank you. We do have a couple questions that have popped in, so I don't want to ignore those. So we have 2 questions from Albert. The first question is, what is your judicial philosophy on sentencing and punishment? Do you actively embrace judicial release? How do you make judgments on when early release of offenders is appropriate? So I know Judge Kelley was kind of, you know, mentioning some of this. As maybe this is a good transition into this question. So why don't we start with you, you know, whoever wants to take this one first. And maybe what we'll do is let's start with the, you know, because the common pleas judges, let's start with you. And then I'd like to hear from, you know, our juvenile judges, because I'm sure there's a different, maybe a different philosophy or a different, or is that maybe there is, maybe there isn't.
Well, I'll start if nobody else wants it. So in terms of philosophy, again, you have to, again, every case has its unique facts. Every case has a defendant, victims, like you've got to take everything into consideration. In addition to that, we are, you know, the Ohio Revised Code provides sentencing guidelines that we don't have a lot of discretion to deviate from when there's a certain plea to a certain charge. There are minimums, there are maximums, and that's kind of our discretion. The things you take into consideration, you know, the overriding, I've almost got this memorized because I say it for all of our sentencing. You know, the overriding principles of felony sentencing are to punish the offender, to protect the public, and to do so in a way that, you know, uses the least state resources, community resources possible. But that being said, it's true. You know, you have to look at the seriousness of the offense, the victims, the possibility that you know, is this a risk to the community, in making that decision. But we are fairly well guided by the Ohio Revised Code and what we do. Thus far, I'll say in my sentencings, I have tended towards the closer to the minimum sanction that the Ohio Revised Code allows. Thus far, all of the sentences that I have imposed have been the result of a plea agreement between the state and the defense. And for that reason, everybody kind of gave me their suggestions, and I've followed those. But again, I have leaned closer to the minimum than the maximum or the midpoint for that session. But my you know, I think this is still something that is developing, at least with me and probably with everybody.
Sure. Judge McDonough, why don't we go to you from someone on more of the juvenile side with this question?
Sorry, I was having a little technical difficulty. Yes, it is a little bit different in juvenile court. We're a very different court than the general division. It's interesting in juvenile court, and we actually have as far as we call it dispositional hearings, and we uniquely have an ACP committee, which is an alternative case plan committee, as well as an ODYS committee, which ODYS is the juvenile, like the juvenile prison facility. So it would be the closest similar to an adult facility. And we have a committee there too, which has stakeholders from not only within the court, but a representative from Children and Family Services, the school district, Cleveland Metropolitan School District. They actually present and write a report on a case where that is something that a jurist can consider before sending a child to a residential placement treatment facility or a ODYS facility. We also uniquely have, and we are the only court in the state, and I am sharing this because I just learned it when I met with her. We are the only court in the state who actually has a OD, I might not be saying her title correctly, but actual ODYS liaison who actually meets with the kids, kind of vets kids, watches kids for who would be a good candidate for judicial release, who's really showing that they are ready to re-enter the community. And as well, I've been honored to take over from Judge Ryan, the re-entry court for our court. So we actually focus on every single kid that gets, and this is also unique in this, for the only court in the state that has a juvenile re-entry court. And I'm still learning a lot about it. So actually Judge Ryan can maybe even tell more about it, but we actually have every single kid that is getting released from the Ohio Department of Youth Services participates in our reentry court and try to wrap in the community for a successful reentry. So yeah, it is a different focus for juvenile.
Makes a lot of sense. We have another question that came in from William. I think this is a good one. I'm going to ask this one to Judge Ryan on the 8th District. What can we do better as legal writers?
First, make sure that you're editing the documents that you're sending to the Court of Appeals. I've been here for four weeks, and in that span, I've heard at least 10 oral arguments, if not more. And well, let me take that back. I've been responsible for writing 10 opinions for 10 oral arguments, but I've heard probably somewhere in the neighborhood of 20 already. And what I've noticed from some of the briefs that I've read, and there's been a ton of them, is that there've been, minor mistakes that could have been easily corrected if they just edited the brief. So that's one, because by not editing, it draws it. Well, there's an issue of credibility from the writer to the court. And when you're trying to convince the court of your position, please make sure that you're doing everything correctly. Also, shepherdizing cases. I don't know where that became an issue where people weren't, because sometimes individuals will be relying on a particular case to support their position. And then when we look at the case, that particular case has been overruled. The Ohio Supreme Court has a site where they actually list the cases that they are deciding on a daily basis. And so individuals need to check those before they are citing these matters from 1987 or even earlier, and believing that is still good law when it isn't. And so those are some of the recommendations I would give with respect to better legal writing. Also, have someone else look at your documents before you send them. Like I said, not just the mistakes aren't just in grammar, but sometimes they have the wrong parties. So they're doing a lot of pasting and copying, and that is not helpful for you if you are presenting a matter before the Court of Appeals.
Perfect. Thank you. Judge Saffold, from a common pleas judge, what is something we can do as lawyers to improve our legal writing?
So I'll tell you this, I appreciate brevity. I like a nice short brief. You give me 20 pages and you could have done it in 5, and I'm probably mad at you by the time I'm halfway through it. Listen, I shouldn't be expecting to get paid by the word or by the page. If you can give us the points right up front, and also it doesn't make a lot of sense to me, and I'm not a practitioner anymore, but it never made a lot of sense to me to sort of throw it all against the wall and see what sticks, particularly when you're writing to a judge. Figure out what your issue is. Don't give me 19 issues when there's really only one strong one. Focus on the strong one. But I do want to chime in on the sentencing.
Sure.
And forgive me, judges, because you all had to listen to me to say this on the campaign trail. But our prisons are busting at the seams. Our county jails are busting at the seams. And the answer is not to build more. That hasn't worked. Mass incarceration hasn't worked. So we need to be more creative in our sentencing. And I would encourage lawyers to be more creative in the suggestions that they make to us for us as to how we might sentence their clients. Because as Judge Kelley said, you know, we might be leaning towards incarceration because we feel like, you know, the circumstances of a given case direct us that way. But we might still be comfortable with a minimum sentence. And if we're thinking about a minimum sentence, maybe we ought to be thinking about something else altogether. Rather than just sending somebody to prison for a minimum sentence of 6 months, they get home and they're just the same as they were when they left, although maybe weakened because now they've lost a job and lost contact with their family. So, you know, we really need to be thinking about creative alternatives to incarceration. And I have to just give a shout out to my fellow judges, because this really is a fantastic group of new judges who have that sort of spirit that they had before taking the bench. And I know that they're coming to the bench with that same spirit.
Perfect. That actually is a good transition into another question we got from Lori, which was, will you work to reduce incarceration pretrial as a system? And if so, how? Will you work to eliminate cash bail, as is now the case in other jurisdictions, including the state level? So I'm going to just open that up to whoever wants to answer that one first.
I'm happy to start.
I was going to say, we're picking up right where you left off.
Yeah.
Obviously, the answer is yes. You know, listen, I'll share some candor with you, though. Judge O'Donnell and I are on the same floor in the Justice Center, along with another new judge. They refer to it as the freshman floor. But you know, we've both come at this from the same perspective, wanting to help people, want to be a positive impact on people. But when the rubber meets the road and you have these cases, it's sometimes difficult. You know, you have somebody who's charged with domestic violence and they're already on probation to you for domestic violence. And now it's a felony, a higher level felony domestic violence. And they're asking you for a bond reduction, and they're asking you to lift a probation hold. Well, you've also got to factor in the situation that the victim finds themselves in. You know, they're concerned legitimately that this person's released. If the probation hold is lifted, there could be reprisals. And so you agonize over this stuff. So yes, the answer is that we want to reduce the population in the county jail. We want to use some of the technology that's at our disposal, the GPS monitoring, the inclusion-exclusion zones. But at the same time, we also have to factor in the safety of the accused. And we have to look at the facts as a bit of a peephole into whether or not, we're peeking into the facts, that is, even though they haven't been proven, because we're required to with respect to bond. And we also have to do that same kind of analysis on some level with the probation holds. So it's tough. You get people in jail that you might want to let out because they're low-level felonies, but if they're felonies that cause you concern for the safety of the community, you got to factor that in too.
Yeah, that is, I think what Judge Saffold said is spot on. When I was first, came in office, I looked at my jail list, and I went through, and my bailiff contacted the attorneys and the prosecution, like, why is this person here? And, we fast tracked a lot of cases, but again, you've got somebody who is on, if it's domestic violence, and, you think you're doing the right thing by having their court supervisor released with GPS monitoring. But then, unfortunately, what do you do when they violate the terms of their CSR by approaching the victim or being in that exclusion zone? There's got to be you got to balance the safety of everybody when you're making these hard decisions. When I first got here and I was able to take office a little bit early because it was an unexpired term, I really, kind of moved heaven and earth would be a bit of an overstatement, but there was somebody who was eligible for a bond modification, was picked up on capias, and I wanted this person to be out by Christmas. So, I did what I could do. I talked to everybody. I did the journal entries, and it was a heavy lift, but we were able to get it through because it was getting on. Well, I come back like the next day, and then I get a report that this person cut their GPS off, and they're on the run. So you just you do your best, and you really try to make good decisions for people, but it is not, it's complicated. And I had always been a believer in, probation as an option, but the challenge with probation is that, it sets up hurdles as well in terms of people being able to get downtown and report, drug testing. So it's just, this is a I think all of us, at least on this panel, share the values of, dealing with the issue of mass incarceration. Pretrial detention, I think, is something that we do everything we can to minimize, but it's just not as easy when the person has to make a decision. It just becomes a lot more complicated.
Sure. That makes sense. We've had a couple of questions that have come in, and I'm feeling called out as a civil attorney, but there's been one question came in from an anonymous attendee. There's been a focus on criminal law so far, so we're going to shift to on the civil side, and this is pretty much geared towards those in the general division. What advice do you have for civil practitioners that come before you? How do you anticipate handling these cases? Since most of you do not have experience practicing on the civil side. I do know some of you do. So we're going to open that up to you guys.
Sure. So as was mentioned before, brevity is key. Making sure that all trial briefs, witness lists, motion in limine are exchanged so that we can try the case when the trial is set for. There's a lot of volume in the court, and one thing I learned when I took the job is that you can't just schedule a trial in 1 week and then move to the next, because trials so often settle or plea. You've got to book 2 to 3 trials, in any given week if you want to keep up with your schedule, knowing that 2 or most of them are not going to happen. So that being said, what is this? Sorry, there's a pop-up on my, okay. That being said, to the extent that the litigants can get their stipulations in, can focus the issues for trial, and make sure I'm going to require that all civil litigants appear in person, parties at the last pretrial, and just I do have there's a couple trials that are queued up for me, and those are just going to be the requirements, because if we are fighting over motions in limine, if we're fighting over exhibits, day of trial, that's going to take a long time. And I would say that I'm also looking at if there's a backlog of motions that I'm trying to rule on, I'm trying to not just do a journal entry so that the parties have some sense of why I ruled one way or another. But really it's just preparation. It's getting all of those things that all civil litigants know. You've got to get your trial brief. You've got to get your witness list. You've got to get your exhibit list. You've got to get your motion in limine. The more time that you can give the court, the better, because I approach this as a civil litigant, but the criminal stuff is consuming, and it really does take up a lot of time. So that's why I would really encourage the litigants to have that level of cooperation, submit their documents as far in advance as possible, and allow the court to try the case on the day of the trial and not deal with small motions or small issues that have not yet been resolved.
Sure. There's kind of a part 2 that came in from another question from David, which was, for the general division judges and with civil cases. And Kevin Kelley, you kind of alluded to this, Your Honor, but I want to open this up to the other general division judges also. Do you believe in taking an active role in attempting to settle civil cases, or is this an area you prefer deferring to the ADR department?
So when we were on the campaign trail, they told us never to talk about our staff attorneys, because the fear would be that people would think that you're putting everything on your staff attorney. All right, so now that I've been a judge for the last 4 weeks, I have to tell you, having a good staff attorney is I can't emphasize enough how valuable it is. Having somebody who you trust to do a lot of these daily interactions. But I'll also tell you that I've invited my staff attorney to let every civil attorney know that I would be happy to meet with them. Every pair, they're welcome to ask to speak with me, and I make myself available. And so what's interesting is that we're 4 weeks in. I've only had 1 pair of lawyers take me up on the offer. So just so that the civil attorneys know, if they want to meet with me, sit down with me, whether it's in the name of trying to help resolve a case, or if it's opinion they want sort of generally to hear my thoughts on a motion or an issue, I know I would make myself available, and I'm just surprised that not more attorneys have taken me up on the offer.
Judge O'Donnell, do you think you plan on being more involved directly with some of these civil hearings, like pretrials, or trying to help be active in helping the parties try and resolve cases, or defer more towards ADR?
Well, I certainly echo everything that, Judge Saffold stated about, the court being available. And, I've certainly, kind of relayed that to my civil staff attorney, who I believe is on the call. So shout out to Christine Sweeney, if you're listening. But, I think, we're all fortunate that we do have experienced civil staff attorneys who are, meeting with the parties on a regular basis, relaying to them that, the court is here if you need anything. But I think there is also an expectation, that the parties themselves are, staying in contact, and that, they're working towards resolution when possible, and when not possible, that, we're gearing up for trial and being ready. So I think the short answer is, while I'm certainly available to participate in these discussions, I think as a judge, it's also important both on the civil side and the criminal side to not overstep. And, we're here if we think resolution is possible, but if not, everyone does deserve their day in court, and certainly, they're going to get that as well.
Excellent.
I will always meet, at least for the final pretrial, with the parties, and I want somebody with settlement authority there. I've had some success in settling case. So far it's only been one case that's been settled at a pretrial, but I'm not shy. Well, if the parties agree to ADR, that's their choice, and I certainly wouldn't stand in the way. But I kind of see that as a separate question as to a judge's involvement. I don't think there's anything wrong with reminding the people in the room that going to trial based on the amount of discovery that is already in the record, that we've already exceeded the value of the case. And while I think the parties know that, maybe they're just too close to it, and having the judge say, I don't know what you think it's going to cost to try this case, but the value of this case, is only X. And I think that friendly reminder has gone a long way in a couple of cases that I'm familiar with, to pushing settlement. But I'm happy to meet. I like being involved at least. I keep a close eye. I have a great staff attorney as well. But my requirements are, if we get to a final pretrial, I want to be there. I want to meet with people, and I want to find out where the case is at.
If I could jump in real quickly, because I know that the questions are more, or this question in particular is more at the general division. However, we want your members to know that the majority of the juvenile court cases are actually civil cases. Judge Ryan and Judge McDonough can attest to that. The majority of our cases, although everyone is, I think the members are more familiar with delinquency cases, we do abuse dependency cases, and then more importantly, we do a lot of private custody cases. And as we've seen statistically, with marriage rates going down and children being born out of wedlock, Judge McDonough and I can both attest that that's been the bulk of our dockets. And Judge Ryan, I think, could agree to this. And so, your members' questions about ADR and some varying forms of dispute resolution, I think, is something that we all heard on the campaign trail. We want your members to know we've, in Judge McDonough and I, our first 4 weeks in office, we've already formed study committees in conjunction with Domestic Relations Court about adding some more mediation departments, adding potentially some conciliation magistrates to help move our civil cases along. And as the general division judges all said, I think that so many times lawyers are afraid to actually come to the judges about those cases. We're all, I know, speaking with it from everybody on the panel, and as Judge Saffold said, we're definitely willing to talk to any lawyers, and that's important to know that, even though they're probably dealing with our magistrates or staff attorneys more on civil matters, that these do make up the bulk of all of our dockets.
Okay. No, I appreciate you sharing that and jumping in. And I think something that you mentioned alluded to something else that I did want to bring up is, you're learning what you need to do to help kind of deal with some of the issues you're discovering on the bench. And that sort of leads into, you as a panel have been in your new positions for 4 weeks, a month, somewhere in that range. You went into this position with expectations of what you thought your day-to-day job was going to be, and now you're 4 weeks in. So I'm curious as to what was that expectation versus what the reality is that you've encountered. So Judge Ryan, if you want to start us off with that one.
Thank you. I know I've been quiet because most of the questions have been geared to the general division. Nevertheless, with respect to my expectations were that I was going to do a lot of writing and a lot of reading. And in fact, they've met that expectation. In fact, when I started on December 20th, I was actually the lead judge on the motion docket. Now, I was fresh out of new judges orientation. I had a brief orientation here, yet and still I was the lead judge for those particular cases. And I was also on the first two panels of the year for arguments. And so it was a baptism by fire for me. So I was not expecting that. I thought I would be given an opportunity to have some grace period before taking on these cases. Nevertheless, I was actually required to make those to hold those hearings and oral arguments, and actually actively participate in the oral arguments by asking questions as well as answering any questions that were posed by counsel. What I saw as a benefit for me that really helped me be more acclimated to the position was I have two excellent staff attorneys that have been here at the appellate court for probably more than 10 years. And so they understand the protocol, they understand what's needed from the judge, and they are huge assistance for me. I'm thankful for the work that I'm doing. I have to say this, that I will probably have to get a new eye prescription after probably 6 months, because I'm doing so much reading and again, so much writing. And it's not just reading the cases, the briefs that are before me, but also reading the briefs that my colleagues are putting out so that I'm either concurring or dissenting from those particular opinions. So they did meet my expectations in terms of the type of work that I'm doing. It's much different from where I came from. The pace is different. I went from hearing 100 cases as a municipal court judge a day to about 20 as a juvenile court judge to now 9. So.
Interesting. Judge McDonough, we haven't heard from you in a minute, so I'll throw the same question out to you as far as expectations and reality.
Yeah, I was thinking about that question, and I really thought that I really understood exactly what I was getting myself into, because I've spent most of the second half of my career working closely with multiple judges, and I've been working at this court for a long time. I guess something I am surprised by was the sheer volume of the work and what you are responsible for. We have a lot of magistrates here in child support and private custody, abuse, neglect, delinquency, and I think I'm forgetting traffic. And we have to oversee and approve all of their decisions, deal with all of the objections, motions to set aside, in addition to our day-to-day docket. And you do feel once you're, this is maybe sound cheesy, but you do feel the weight of your position in a way that I maybe didn't expect to, and the weight of your decisions. And I would also say that I am surprised. I am exhausted at the end of the day in a way that I maybe have never been in any prior position. So that's what I would say.
Sure. I have a couple other questions that have come in. This one's just directed particularly to Judge O'Donnell. You had mentioned your unique background of coming to the bench from the public defender's office. How does that impact your decision-making on the bench?
Well, that's a great question. So for me, one of the things that I find myself, constantly being mindful of is, this change in roles for me. Because as a public defender for the last 14 years, I was always the advocate. I was always the one who was, just really expressing the wishes of my client, fighting hard for them, fighting hard for justice, fighting hard for fairness. And while, the justice and fairness part hasn't changed, I am now the neutral. And so I'm always, being super mindful of that, when, motions for judicial release come across my desk or motions for bond reduction, because, having written countless motions like that during my career, it's like I kind of have to, say, okay, I need to take a step back and, really kind of weigh, obviously what the defense attorney is asking for, but also, what does the prosecutor's response say? What does the safety of the community dictate? So for me, it's just a constant reminder to be in the middle while still, being just and fair. But I think beyond that, my experience as a public defender, particularly, there was some discussion earlier about, pretrial detention. And, I think that I have maybe more of a depth of knowledge on the way that how that can impact criminal defendants when they're in jail pretrial wise, not only for the disruption that it causes to their lives, but, as an attorney, as a defense attorney, more specifically, the difficulty in preparing a defense when your client is incarcerated. One of the first things that I did on my docket is I released an inmate from the jail who had been incarcerated for over 700 days. And he has a lot of charges, but the charges at the end of the day are nonviolent. And one of the arguments that his counsel made that really struck a chord with me was that, this is a case where there are hours and hours and hours of surveillance video. And the lawyer says to me, Judge, I can't even get a block of time in the jail large enough to sit down with my client and review the surveillance video. My client doesn't even have a sense after 700 days of what the evidence is against him. And that was something that really resonated with me because that was something that I've experienced in practice. So, we found a way to put him on a GPS monitor to hold him accountable, but to still, do what I felt was, just and fair in the situation. So again, I'm using my experience as a public defender in some ways, but I'm also, again, trying to stay in the middle and be neutral.
Sure. And I think it's an interesting point. I think each of you have your own unique background, something that you each bring to the bench. But at the end of the day, people are looking for consistency before the judges. I think as lawyers, there's always going to be the conversation of, the hope of which judge you draw is sometimes, is a luck factor that I think some lawyers pay more attention to than others. But as judges, what are some of the things that you work towards, despite, your unique backgrounds in bringing consistency, to the bench? I know with civil cases and criminal cases, there are, rules, of different procedure, evidence, local rules. But, what are some of the things that you guys work towards as far as that?
So I'll tell you, one of the things that has surprised me, and I would even say disappointed me, is that we are like 34 islands as judges in the Common Pleas Court General Division. There's really not a lot of interaction. We had, I think in the last month, we've had one meeting, unless they had some others and they just didn't invite me. It was just the one. And somebody was a guest speaker who spoke for like the whole meeting, and then we left. So there really isn't an opportunity for us to create a sense of consistency, because I have no idea what's going on across the hall unless I walk over and ask Judge O'Donnell what's going on in her room. So it's unfortunate that there isn't more interaction between the judges, and there's not more opportunity to sort of find consistency.
I'll chime in to say that we're just the opposite at the 8th District. When I first started, my door was open, and I can say at least 10 of the other 11 jurors came in, one, to welcome me and to also indicate that whatever I needed, they were there to help. They introduced me to their staff members and said if their staff members needed any assistance, or if my staff members needed any assistance, they were there to provide that. Why? Because we want to speak as one voice as the 8th District, so that we are giving what's necessary to the trial courts in terms of the law to follow, so that there's consistency there. I think we look for that. We look for consensus when we're making decisions on cases that come before the court. Will there always be consensus? No, but there has to be at least two people agreeing before a decision can be affirmed or reversed. And so I think that's, something different than what I've seen when I was a judge at the Cleveland Municipal Court, as well as Juvenile Court. Although Juvenile Court, I have to say, we had worked more together to try to make sure that we were speaking as one voice. That wasn't necessarily the case at Muni Court. There were, like Judge Saffold was saying, 12 islands, individuals making their own decisions on cases. But here at the 8th District, we do try to speak as one voice.
Judge Celebrezze, do you have a comment on this as far as the judicial judge representative for this question?
Well, I always have to defer to my senior judge, Ann McDonough, on this one. She makes sure she coaches me on all my answers, makes sure she has pre-approval of all of them. But no, I think, as Judge Ryan said, Juvenile Court, just because of the makeup and the smaller body with only 6 judges here, we have a pretty open discussion pretty regularly. We've only had one official judges meeting, but I know that, and I think having 2 of us come in at the same time, so four of us that have been on the bench before, and then Ann and I coming in together, I think that's helped too. I know both Judge Tom O'Malley and Jen O'Malley, as well as Judge Floyd and Judge Sweeney, have all come down to my chambers, and even just yesterday, I walked over to Judge Floyd's to ask her a question. I think just the nature of our building setup, it makes it a lot easier than it does at the Justice Center to navigate. But yeah, we've had a good collegial relationship. I think our biggest difficulty is where the general division is the 34 judges we have, and how many magistrates do we have? And I think that's where we see more of a differentiating of opinion sometimes, is coming from the magistrates up to us, not the other way around.
Interesting. We are running out of time. We do have a couple extra questions that have come in. And I apologize if we're not going to get to them. I do kind of want to end on one overarching question. And this was something that was, brought up. I think Judge Kelley brought this up in your introduction, and it's worth, I think, going around for everybody on this last question, which is, how do you measure success from your position on the bench? I know it's a lot, it's goal setting and you accomplish those goals, but, for each of you, what are some of those goals? And then, how do you intend to measure your success during your time on the bench?
Can I start?
Sure.
For the Ohio Supreme Court, they measure success by the number of cases that we don't have over age. Okay. And so that's what they indicate is a successful docket. For me, it's that, but it also includes not having reversals from the Ohio Supreme Court. That's another measure of success. But a real measure for me is how I have impacted the individuals that come before the court. Routinely, when I was a judge for municipal court and common pleas juvenile court, I would be out in the community and someone would approach me and say, Judge Ryan, thank you for doing this or that for either themselves or a family member or a friend. And so that for me was a acknowledgement of the work that I was doing. Sometimes I had individuals who come up and say, I disagree with the decision that you made, and this is why. And that helped me in terms of improving the work that I was doing on the court. So the testimonials that I get from citizens in the community is a measure for me of the success that I've had on the bench.
Let's go to Judge McDonough.
I guess I would echo a lot of what Judge Ryan said as far as what the Supreme Court measures as success, and then also being mindful of and very deferential to our 8th District Court of Appeals and not getting reversed. It would also be important to me. I think when I think of it though, I think it's a commitment to myself, and that in this position, I would stay committed, focused, well-researched, and make thoughtful decisions on each and every case, and hope to make an individual impact on each person, as well as I hope, and this is I hope to make a systemic impact, at least for court-wide, in moving our court forward in total. And because, especially because we oversee the detention center and the clerk's office, which is kind of different for a court too. So I guess that's what I hope.
Sure. Judge Kelley?
So I'm gonna kind of stick with my original response. I know the Supreme Court has their guidelines. I inherited a docket that was, needs a lot of work. So I'm not going to be guided by any artificial numbers. I'm going to try to find a just result in every case. And I think, in doing so, I'm always mindful, not to let the volume, not to let the job become just a job or get jaded with things that I see. To try to look at both, how can I be part of any systemic change? And also how can I be part of an individual change for the individual defendants that are before me? Now I'm still assessing what that is. We're all new. I don't want to go out guns blazing at this point. I'm just kind of learning the building, learning the job, but I certainly see things that I think can be done better. And I just really try to, my measure of success is, have I treated every attorney, every defendant, every plaintiff, every person that's come before me with the respect that they're due? Have I made sure that I'm the judge that I set out to be when I started, which is to treat everybody with the profound respect that they deserve, because most people don't come to court because they want to. And if I do all those things, I do believe that the numbers that other people hold me accountable for will naturally come into line.
Judge O'Donnell.
So great question. And, I echo so much of what has been said by my colleagues, both in the juvenile division and in the common pleas division. One of the things that, I'm going to always use as a measure of success is how and when I'm using incarceration and when I'm considering alternatives. One of the things that, we were told at judge school, and one of the things that I've heard from some of my colleagues on the bench as well, is that, prison should really be reserved for people that, we're afraid of, for people that truly pose a risk to the community, not for people that we're mad at. And that's something that I'm always mindful of. And I find myself kind of, when I'm reading a pre-sentence investigation report or when I'm listening to arguments at a sentencing, it's always something that's kind of in the back of my mind, as far as, what is really going to be appropriate. And additionally, what's really going to serve the person before me? Is this something where some of those alternatives to incarceration, such as, the community-based corrections facility, intensive probation services, mental health treatment, substance abuse treatment, are these things that are going to be, better served to stop this revolving door of the criminal justice system that a lot of the defendants coming before us are experiencing? So again, that's something I'm going to use as a measure of success. And additionally, although each case is unique, just having some uniformity in sentencing and, being mindful that, I am, while I'm treating everyone as an individual, I'm also kind of always in the back of my mind thinking about what I did with a person who was similarly situated, because I think that that's important. I think that, is going to keep me in the middle and keep me grounded as a jurist as well. And lastly, just treating everyone with dignity and respect. That's a huge measure of success for me as well.
Absolutely. Judge Celebrezze.
So for me, the first 30 days, it's been able to fall asleep at night. This job to me has been strange. And when I was a practicing lawyer, and I did primarily divorce work, but I could definitely not get my heart attached to those cases. I've seen being a judge where I thought it'd be the opposite, that I would not have any emotion involved in when these cases are in front of you. It's been actually the opposite for me as a judge, where I actually take these to heart a lot more, because I am making the final decision. And especially in juvenile court, more so when in the delinquency cases and sentencing people, but when you're taking someone's kids away in a permanent custody matter, you're permanently taking a parent's child away. As a father myself, those really weigh hard on you. And I go home and tell my fiance that all the time. It's just hard to really deal with that. And it's something that I didn't think I would struggle with as much as I do. And so the fact that I can go to sleep at night makes me believe I'm at least doing the right decision. So I think in my first month in office, to me, that's how I've measured my success.
Yeah. And last but not least, Judge Saffold.
So, I've practiced in Cuyahoga County for over 2 decades. And I've probably practiced somewhere between 50 and 100 judges. And so often I saw what I regarded as just a callous disinterest or indifference, at least, about the needs of the defendants and even the victims, frankly. And so it's just refreshing to hear all these judges talking about how they're going to measure themselves based on their ability to impact on people in a positive way. That's just, I can't tell you how much that warms my heart. Even though I'm on the panel, if I was just, somebody just tuning in, it would be great for me to hear that kind of thing. That's awesome. And, so I'm not going to belabor it. Obviously, I don't really care about the numbers. And I'm also not afraid of Judge Ryan of the Court of Appeals. If they want to overturn me, they're probably wrong. I was still right. So you just have to do what you believe is just. There was a questioner who asked a question anonymous. I just read in the chat and said something like, how do you balance the jail population and your concern for overpopulation with all the violence that's going on in the community? And it's a fair question, but I would leave you with a statistic that all of these judges have heard me say probably 1,000 times. When you look at the prisons in Ohio, 80% of the people in prison in Ohio are there for nonviolent offenses. 20% are there for violent offenses. So it's a small fraction, it's a fifth of who makes up the prison population in Ohio. So we can get excited about violent crime all day long, and we can get excited about the news stories that lead to news. But those cases are kind of easy. Frankly, I've probably agonized over those cases less. There are certain actions on behalf of defendants that just, it's easy. You don't stress up. You don't take that home at night. But so the cases where prison is sort of obviously called for, those aren't the real difficult cases. The lower level cases where you're trying to help people, that's where we sort of, this group at least, I know, we look forward to it, and we spend a lot of time thinking about it. How can we help these people? And in terms of satisfaction, Judge O'Donnell and I had this exact conversation the other day. The question is, at the end of the day, and I think maybe Judge Celebrezze kind of alluded to it, at the end of the day, do you feel like you were able to help people? Do you feel like you were able to do something that benefited people? I bet you Judge Celebrezze would say that when you think about having to take away somebody's child, you're also thinking about that child and the years ahead of that child, and how maybe taking that child away from that family might put him ultimately in better stead, in a better position for success. It's, the measurables are really, in my mind, useless. It's more electing judges who care about the people that they're judging.
Perfect. And that wraps up our time. Thank you all. I really appreciate you guys sharing your insights. It's been, as the moderator, it's been, fantastic. I can't even begin to thank you all for your time.
Thank you. Thanks everybody for tuning in.
Thank you.
Yeah, thank you everyone for giving us your time. It's nice to have you all in one place. For those of you who need CLE credit, I will be hitting your inbox here shortly as soon as we hit end here. But thank you all again for tuning in, and we hope to see you next time. Have a great day, everyone.
Thank
you,
you.
everyone.
Take care.